And of course, from the title we can see, and we have maintained that in the past the OCIJ has been less than forthcoming when it comes to making expedited or even normal decisions. Perhaps they're overworked, perhaps they don't take our submissions as seriously as we believe they should be taken. Then on June 19, 2008...
May I have Your Honour's indulgence in this matter? Your Honours, what my learned friend is arguing are applications that have been disposed of, decided or handled by either Your Honour's chambers or the investigating judges. As I submitted, what is before Your Honours right now is a detention extension appeal, whether the investigating judges on the 11th of November 2008 rightly extended this detention. The investigating judges rarely mentioned the health issue of this accused in their impugned order because the objections that my learned friend filed on the 28th of October did not mention health issues. Therefore, if my learned friend seeks to re-argue all the applications that have been decided, then that would not be the right forum here, Your Honours, and it would not be the appropriate time to do this. And the other thing is, if health is an integral part of the provisional detention hearing, then it should happen in the presence of Mr. Ieng Sary. As I submitted, if my learned friend wants to compartmentalize this appeal, then he has to very categorically tell this Honourable Chamber as to what is it that Mr. Ieng Sary wants to be argued in his presence and what it is that he doesn't want in his presence to be argued. That's my submission. I apologize for the intervention.
If I may briefly respond to this particular intervention, we're maintaining that the health issue is part and parcel of the appeal process, but obviously my learned friend fails to comprehend that one cannot discuss the health issue unless one actually knows what the health issue is all about. And that's what we're maintaining. We cannot make adequate submissions concerning the provisional release appeal because we don't have the medical testimony, we don't have it all, and we do believe that Your Honors should have it. We do believe that you should be in the best possible position. And what I'm demonstrating here is this health issue is not something that just popped up. I will further demonstrate, aside from the documents of the 19th of June, 30th of June, 19th of January, 9 February, and 20th of February, you will see, if we go on to the next slide.
Perhaps you can give the pre-trial chamber some time to deliberate on the intervention made by the prosecution?
Very well, Your Honor.
Du coprocureur. Merci. Oui, dit Maître Carnavas.
The pre-trial chamber is it's finding of the pre-trial chamber that the prosecutor is correct, that you are making your argument already and not responding on the issues raised by the prosecutor related to your request to argue. So we would like you to stop the PowerPoint presentation but go into the arguments raised by the prosecutor so that the pre-trial chamber can consider all the arguments and whether to continue either on the provisional detention and appeal and or on the request made on behalf of the defense.
Okay, thank you, Mr. President. Thank you, Your Honors. And my apologies. I wanted to give you the sufficient contextual background, but I'll get straight to the point. Of course, Mr. Ieng Sary has indicated that he wants to participate. He cannot participate because of his health. So it's not some sort of a tactic that we're being accused of, either by the prosecution or by the civil parties. As far as having Mr. Ieng Sary present to give us instructions, let me just say one thing. First of all, on Monday when I came, I met with Mr. Ieng Sary very briefly. He was too tired. Even though I had flown from Europe on that day, he was too tired because of his medical condition for a proper conference that we had already pre-scheduled. Later on, he went to the hospital. We were not able to see him in the hospital. Yesterday, we did go. We were not allowed to see him. Yesterday, when he came back, we saw him. He was very weak. And he specifically indicated that he wanted to discuss this entire issue with us, and that since we hadn't had time to properly meet, that he wasn't prepared to go forward, but he was going to think about it. And then so we were not able to actually meet with him yesterday to have a consultation. We saw him in his cell very briefly. We had met with the doctor for approximately an hour before that, where we were discussing Dr. Falk's report, and I'll get to that as well. And then this morning, he was examined, as is the normal procedure. I believe he's examined every day and sometimes several times a day. And it was the doctor's opinion, not Carnavas's opinion or Mr. Angudam's opinion that he shouldn't be here, but it was a doctor's opinion that, again, he was very frail and had high blood pressure and was unable to be here. And it, my understanding that he was also unable and physically not fit to even be transported, say, downstairs to some facility where supposedly he would be able to follow the proceedings. Now, we have to keep in mind that yesterday, and we can have the doctor here, I was able to see the number of medications that the gentleman is taking. And the medication is not only affecting him physically, but also the question is he competent to mentally follow the proceedings if he's under such medications? I'm not a doctor, so I don't know these things. I know one thing, that I misused one term when I said stable, and the doctor told me that's a in medical terminology, that's how they put it, that somebody is stable under medication, not that he's fine and well, because they don't use those terms. So, lesson learned, I'll try not to use medical terminology in front of the co-investigative judges or anyone else. So, from that perspective, it is our submission that he is not able to attend today. Now, the question is, are we parceling our argument as the prosecutor is jumping up claiming that we're doing, or are we making a separate argument saying that, look, since we are unable to go forward, on this provisional detention hearing, since you've already opened the door that matters can be raised at a separate point, and we would say that this might be that point, but also more importantly, since the decision that we see that came out on the 23 January 2009 has some errors in it, and we believe that either misconceptions or misinterpretations of our particular positions, as was stated, that had the pretrial chamber, with all due respect, been somewhat more careful in reading our submission and looking at the entire record of what is before you, we do believe that you would have come to a different conclusion. Now, we're not here to argue his medical condition. We're not arguing that Dr. Falk is an expert giving an expert opinion as to what his state of, Mr. Ieng Sary's state of health is. What we do believe is that this is an opportunity for us to explain to the trial chamber some of the errors that are found in the 23 February 2009 decision, to try to persuade the pretrial chamber that indeed it is seized with Mr. Ieng Sary and the health issue is before you and not before the core investigative judges, and that you cannot make a proper determination unless you have testimony from experts. We're not the experts. And of course, we do understand that in the civil law process, usually experts are brought in by the court, and of course the court usually does the examination, and we're perfectly fine with that. We believe that questions should be asked. Should all the doctors come in? Should some? I don't know. We leave it up to you, but we do believe that some of the major doctors should be coming in. And what Dr. Falk's report is all about, which is being misinterpreted by the American colleague here, is not that he's saying that, anything that we may not necessarily know as far as old people and their conditions. But what he is saying, from the limited medical documentation that his defense counsel are able to get from the ECC, from the doctors here, from the OCIJ, from those limited records, because there may be others which we don't have, but from those, what he's able to see is that certain testing isn't being done, or hasn't been done, has not been done, and he's making certain recommendations. That is all. And the purpose of inviting him to testify by a video link was merely to give you the proper information as to how, for instance, at the ICTY, where they had Milosevic, and he was the treating physician, and they had others who are being held in detention, what sort of examinations they perform, and perhaps what examinations should be performed here or should be considered. And it's for you then to decide whether indeed those examinations would be necessary. So I believe we're not trying to compartmentalize, because this is not part of the hearing that we're here for today, for which I have no instructions to go forward without my client's instructions. What I am saying, that when we do go forward at some other point, that we have all the necessary documentation in advance, and that you bring those individuals before us for that particular hearing in order for you to make a determination. So those are my submissions. And I can show, I can demonstrate through my PowerPoint presentation that it takes, for instance, 6.45 months to make an average decision here. The one on translating the orders was 8 months, and the one on provisional release, the last one, was 11 months in total. Now, granted, that's looking at it rather superficially, but for the prosecution to suggest, as they're suggesting, that somehow we go back to the core investigative judges, raise this issue again, wait for them to make a decision, and then somehow get it before you, we're saying you're seized with it, because in the past you have indicated that for matters concerning issues of provisional detention, you're seized, and you can look at the entire file, not part of it, not some of it. And we dare say that you don't have all of the file, you don't have all of the facts, and that's what this is all about. So the hearing that we're asking for today is on that very limited basis. We're not arguing anything more. We're not saying that he should be released or not released, but merely that at this point in time, we believe that there were some glaring errors or misconceptions in your 23 February 2009 decision, that upon reflection, upon reflection, you should consider having a hearing with those doctors and to make it part and parcel of a hearing when Mr. Ieng Sary is healthy. And also, we think it is wise to have Dr. Falk appear via video link to answer your questions. And I think that it makes sense. It makes sense because if something were to happen to Mr. Ieng Sary, at least we can say from this point of view that all that was necessary and all that was possible was done. So I believe I answered the questions. If you have any specific questions that you believe I haven't answered, Your Honor, I'd be more than happy. But I think it is a red herring, if I may use that analogy, or it's a false argument for the prosecution to be suggesting that we're trying to have two separate hearings. We're not. We're not going forward on the provisional release hearing, period. And we do not believe that Mr. Ieng Sary is able to participate, and I think to have him somewhere down in the building where he's drugged up, hardly knows where he is, can hardly follow the procedure, and to say somehow this meets the international standards or principles which this institution is supposed to abide to, I think we're kidding ourselves. I think it would be a sad day for justice in Cambodia, and it is the prosecution that argues that this is an international or internationalized tribunal. However, we can see quite well that when it suits them, they want to go subnational, not even national, certainly not international. And so we believe that it would be improper to have Mr. Ieng Sary, who cannot follow the proceedings, have him in the building and say he was present. He was physically present, therefore he participated. That, in my humble submissions, is utter nonsense. Thank you.
Pour dire qu'il est effectivement présent. Merci de votre attention.
I have one question to Mr. Carnavas related to the submissions made by the prosecution. As I recall it, they said either the issue you want to submit on is part of the appeal against extension of provisional detention, and then it should be included in Mr. Ieng Sary's request to be present making the submissions on the appeal, or it is not part of the appeal. And in my view, you did not fully respond on that raised issue.
All right. If I had all the medical documentation before me, and if I were to be arguing that Mr. Ieng Sary is indeed not getting all of the necessary treatment that is required for him, if I were to be going into the substance of that particular argument.
It's just, what's your opinion on, is it a part of the appeal? As you showed the pretrial chamber in the PowerPoint presentation, I thought that maybe can be leading to the conclusion that it is your view that it is part of the appeal, but you did not express yourself.
My view is, and I'll try to be, and I apologize if I'm inarticulate and perhaps not answering the question as best as I can. We believe that at the pretrial detention hearing, the issue of health is a matter that must be considered by the pretrial chamber. We believe, as it stands right now, the pretrial chamber does not have all of the necessary documentation to make a decision. And that's why it is our submission today. What we're submitting today is, when we do have the hearing down the road, that we believe either before that period or during that period, the pretrial chamber should avail itself to testimony from the physicians to make a determination whether he's getting proper medical treatment, whether he's fit to stand trial, and so on. So then you can then decide whether the detention proceedings, or whether he should continue to be detained over here. I don't know whether I'm answering your question, but I don't believe what I'm arguing today is the substance, because we're not saying that he's not fit one way or the other to stand trial. We're not saying that he's not getting proper medical treatment. We're saying we don't know. We don't have enough information. That's the underlying basis of our submission. And we believe that the pretrial chamber doesn't know, doesn't have all the adequate information, because it does not have and has not availed itself to the medical expert testimony.
I have a question. Mr. Canovas, are you in fact making an application under Internal Rule 3110?
Well, I can certainly answer in this way. We're not asking for the co-investigative judges to do anything, because we believe the matter is before the pretrial chamber. And if I look at Article 3110, it would appear that the application would have to be made to the co-investigative judge, unless I'm misinterpreting right now out of fatigue.
I think it reads a request to the co-investigating judges or the chambers to appoint additional experts.
Well, in that event, but we're not asking them to be appointed. That's my whole point. We're asking Your Honors to avail themselves to the experts that are already, the medical experts who are treating him. That's one. And Dr. Falk we were never submitting that Dr. Falk should be appointed as a medical expert in order to examine, but merely to provide the pretrial chamber with information concerning what sort of treatment others are receiving, and then for the pretrial chamber to determine whether any such tests and examinations should be conducted. So it wasn't. We're not advocating him as an expert in a sense that he's going to give a medical opinion as to Ms. Ieng Sary's state of health. But if Article 3110 works, for you it works for me.
It's not a matter for me, it's a matter for you.
Well, we believe, Your Honors, that the pretrial chamber in the past has indicated that on detention of appeals, that they have to take into account the whole OCIJ case file up to date for the hearing, and also that it would conduct its own analysis of Rule 63(3). And this was in the decision on appeal against provisional detention, 17 October 2008, paragraphs 68 to 69. You also held that you have jurisdiction in Ieng Sary's appeal against provisional detention order to modify the conditions of detention and to suspend the detention on conditions, and will take the contents of the request into consideration. So obviously, and this was on 30th of April 2008, paragraph 7. And what we're saying, Your Honor, and again, my apologies for being less than clear and inarticulate, is that we believe that you are seized with the matter at this point in time. It's not the co-investigative judges anymore, because now the matter is before you. And we don't want to be in this black hole where we're going back and forth. Who's in charge? Who is seized? For this matter, you are seized, and we believe, and I am most grateful, Your Honor, for your assistance with 3110, because clearly, for the purposes of the pretrial detention or pretrial detention hearing, it would appear that under 3110 you can seek guidance. Now, we're not asking for the appointment of experts, but obviously what we're suggesting that you avail yourself to the experts, and if having Dr. Falk testify as to what is going on in other UN institutions, if that is considered as being appointing an expert for those purposes, that's fine, and if the pretrial chamber wishes to engage him directly, that is fine with us as well. We have no intention of cross-examining anyone. We would like the pretrial chamber to examine, and of course we could follow up maybe with examination, but we leave it up to you. It is our submission that you need this information, you need it for the next hearing, or for when we actually have the hearing. But those were our submissions, and we were prepared to make this part, and this was going to be part of our variation of this argument. We were prepared to make, even if Mr. Ieng Sary was well enough, because we do believe you've given us the door for some future purposes. But as circumstances have it, Mr. Ieng Sary is physically unable to participate. He wishes to participate, and at this time we don't believe that it would be in the interest of international justice or Cambodian justice or any sort of justice to go forward with a pretrial, with this sort of a hearing, with Mr. Ieng Sary not being physically or mentally capable of being to assist his counsel.
Thank you, Mr. Cannabis. I think you've answered my question.
I apologize if I was a little long-winded, but I just wanted to make sure that I covered all bases. Thank you.
The President, the pretrial chamber shall now retire to deliberation. Please rise.